In an important development, Congress leader Dr. Jaya Thakur has filed a review petition before the Supreme Court of India against the recent judgment in the case of Janhit Abhiyan versus Union of India, which upheld the validity of the 103rd Constitution Amendment dealing with 10% reservation for economically weaker sections, popularly known as the EWS Reservation. On November 7 this year, 4 separate judgments were authored with different reasoning by judges of the Constitutional Bench. 3 judgments by Justices Dinesh Maheshwari, Bela M. Trivedi and Justice J.B. Pardiwala upheld the 103rd Constitutional Amendment, but 1 judgment passed by Justice Ravindra Bhatt along with the then Chief Justice U.U. Lalit had held that the amendment violates the basic structure of the Constitution on the ground of equality, especially due to the exclusion of the OBC, SC and ST from the EWS quota. The review petition states that in Madhya Pradesh, the OBC population is more than 50%, but OBC reservation in MP state service and educational institution is only 13%. The scheduled caste community is 16% of the total population and they've got proportional reservation of 16%. Similarly, scheduled tribe are 20% of total population and they've got proportional reservation of 20%. However, the OBC community is getting only 14% reservation despite the total population being way beyond. The plea further asserts that even though the forward caste population is only 6%, post the amendment 10% reservation for the EWS will be provided to the poor of the forward caste. The plea stipulates further, and I quote here from the plea, the numbers clearly show that this reservation of 10% is disproportionate and there is no grounds or justification whatsoever for arriving at this figure of 6%. The 10% reservation provided to the EWS of only forward caste is breach of equality code amounting to discrimination. The Supreme Court has further been apprised that neither the parliamentary debate while passing the impugned amendment nor the majority judgments give insights as to what was the rationale that was adopted to come to this figure of 10%. The only ad hoc commission which was established in this regard was the Sinha Commission, which too was unable to justify the provisioning of 10% reservation for the EWS category. Justice Maheshwari, the plea argues, gave a contrary finding that the 103rd Amendment is not violating the limit of 50%, which is in fact a complete violation of the law settled in the case of Indraswani. The plea asserts further. The petitioner has further argued that Justice Maheshwari's finding that the exclusion of the SC/ST OBC categories from the 103rd Amendment does not violate equality is completely problematic because the yardstick for the same is one's economic basis only. Justice Trivedi, while upholding the 103rd Amendment, stated that a revisit into the reservation policy is necessary, which is contrary to her own findings in the judgment. The plea asserts further. Referring to Justice Pardiwala's judgment upholding the amendment, the plea submits that the judge had noted that Ambedkar wanted to bring social harmony by introducing reservation for only 10 years. This, the plea states, is incorrect on facts. For more information on the review petition, you can refer to a detailed report, the link to which has been given in the description box below. Thank you. I'm Jaya Thakur for LiveLaw. Keep watching LiveLaw for more such updates.